The one scramble.
Good morning. We're going to get started with the Elections Commission meeting of September the 26th. And we will start with the Executive Director calling the roll.
Mr. Caraway.
Present.
Mr. Polkey.
Present.
Mr. Kirschner.
Present.
Mr. Knight.
Here.
Mr. Lyle.
Present.
Chair Tavares.
Present.
Ms. Hagan and Ms. Davis are not present. Mr. Kolke is present on Ms. Davis's behalf. Mr. Stoutberg has indicated he will not be able to attend today's meeting. We do have 6 members, which stands as a quorum. So we are prepared to go forward. Ms. Tavares, I would ask for a motion to excuse Ms. Hagan and Ms. Davis.
Do we have a motion?
So moved. Second.
Been moved and properly second. All in favor, say aye.
Aye.
Mr. Kirschner. Mr. Kirschner.
It's on.
Oh, it is. Okay. Yeah, I'm sorry. Oh, should it be on or off?
No, we're good.
Okay, that's where we started.
Just
Okay.
remember everyone to turn on your mics when you're going to speak. Thank you very much. Now we're going to move on to the minutes. Everyone's received the minutes. If you haven't reviewed them already, please do so now. If there are no changes, corrections, do we have a motion to
So
approve the
moved.
minutes? Thank you very much. Is there a second?
Second.
It's been moved and properly second. All in favor, say aye.
Aye.
Opposed? Thank you. The minutes have been
Mr. Tavares,
Yes.
can I be marked as abstained since I wasn't at that meeting?
correct. Thank you very much. The minutes have been approved with a vote of 5-0.
Yep.
Thank you very much. Next, we're going to move on to the preliminary reviews. The first one is Osborne versus Wilder et al. That's case number 2024G-027. Mr. Executive Director.
Madam Chair, members of the commission, the complainant asserts that the respondent essentially participated in the electoral process without filing proper documentation, did not include information on his campaign finance report concerning certain expenditures. We did receive a response from the respondent and counsel for the respondent, whereas since essentially it was a personal expenditure which he made. We received an additional document from the complainant, which I have circulated to all of you. Certainly, my recommendation is to find no violation. Certainly, the commission can hear from parties that are present. I didn't grab the attendance sheet. You didn't grab the attendance sheet. I know Mr. Osborne is here. I'm not sure whether there is a representative or Ms. Wilder is present.
Your Honor, on behalf of Your Honor, excuse me, on behalf of Mr. Wilder, Mr. John.
Or Mr. Wilder, okay.
Your Honor.
Thank you. I apologize for saying Ms. because the letter was in support of the other candidate who was a woman, and that's what I was thinking of. So if the commission wanted to hear from the parties, they are certainly present. We could certainly do so.
Do the parties want to speak? Mr. Osborne, go right ahead.
You'll need to be sworn.
Swear to right hand. Swear firm to tell the truth, the whole truth, and nothing but the truth.
We do.
Thank you.
My name is Chuck Osborne. Has 3,218 voters in the ward. Now, like any politician, you're trying to stretch your dollars. There are multiple voters in a single residence. So my mailing, I mailed to 1,650 addresses. If you're only mailing to 789 households, you're only reaching 48% of the voters that you were hoping to influence. Who paid for the mailings for the other 52% of the voters, who I can only assume received a mailing because you state in your affidavit they were sent to Ward 3 voters. With that said, I'll get on with my prepared remarks. I hope I don't stretch this beyond your ability to sit there and listen. With regards to the complaint I have brought to this body this morning, I first would like to express my gratitude to you for the opportunity to speak in support of maintaining respect and adherence to Ohio's laws regarding campaign finance reporting. The complaint before you today is similar in nature and somewhat related to a previous complaint I brought to this body back on June 13th of this year. In that case, the candidate failed to report her 2023 campaign expenses. Not until my complaint was filed in April of this year did that individual, Melissa Owens, report her campaign expenses with an amended filing. This was 5 months after the filing deadline. This commission found a violation in that case. With Mr. Wilder, we're now looking at 10 months past the filing deadline. The complaint before you this morning is similar in that the candidate has failed to report campaign expenses as required by campaign finance laws. In last year's general election, the respondent in this case, Steve Wilder, was running for a third term for North Canton mayor and had no opponent. Steve Wilder had a PAC titled Committee to Elect Steve Wilder that was first created on March 6, 2019, and which has remained open. In addition to appearing in campaign literature for Ms. Owens, Mr. Wilder also mailed out an endorsement letter in further support of Melissa Owens without reporting any expense related to that mailing. Mr. Wilder, in his response to his attorney, states, though Revised Code 3517.10 imposes a reporting obligation on campaign committees, it does not expressly impose that same obligation on candidates like Mr. Wilder. A director at the Stark County Board of Elections, to whom I spoke recently, took a very dim view of that argument when I showed Mr. Wilder's written response to her. If I am not mistaken, this commission rejected that same position when Alan Freeman made that argument before this body earlier this year. I have filed many campaign finance reports regarding campaigns for public office beginning in 2001, as well as for ballot issues I have been active on. I have been successful in placing ballot issues before the voters and in guiding voters to oppose ballot issues placed before them by North Canton City Council. I have made every effort to follow campaign finance laws in those 23 years. When I had questions, the Stark County Board of Elections always provided answers to me. In last year's general election, Mayor Wilder absolutely did not want to see me back on North Canton City Council, and he went all out to see that I was unsuccessful. This is seen clearly on campaign literature of Melissa Owens, where Mr. Wilder is posing in a photo, standing hand in hand with Mrs. Owens to show his support for her. Apparently that was not enough, however, as he took it upon himself to mail out a full-page glowing over-the-top endorsement letter in support of Melissa Owens as well. Mr. Wilder's affidavit raises some confusion with me when under item 7 of the affidavit he states, and I quote, "In support of Mrs. Owens' candidacy, I use my personal funds to pay real-time marketing to mail letters prepared by me to the voters of Ward 3, urging them to vote for and support Mrs. Owens in the November 7th, 2023 election." North Canton's Ward 3 had 3,218 registered voters in last year's general election. Elimination of duplicate mailings brings that down to 1,650 mailings needed to reach all Ward 3 voters. Yet Mr. Wilder is invoiced for only 789 mailings, resulting in a total invoice expense of $959.41. To have reached all the voters of Ward 3, as you would expect, he states in his affidavit, Mr. Wilder would have had to mail out 1,650 mailings, which would have far exceeded the stated expense listed on the invoice he received from Real-Time Marketing and made an exhibit in their response. Mr. Wilder's stated quantity of mailings would have only reached 48% of Ward 3 voters. Has someone stepped forward with the same rationale as Mr. Wilder, thinking that if they expend personal funds, that their expenditure do not need to be reported? If Mr. Wilder's stated number of mailings is to be believed, 52% of Ward 3 voters did not get the endorsement letter, or did an unknown individual pay the mailing expense of the endorsement letter to the remaining 52% of the voters? We will never know. I would also point out Mr. Wilder's printer has been a longtime close friend of Mr. Wilder and was a contributor to Mr. Wilder's 2019 and 2021 campaigns for mayor. Also stated in Mr. Wilder's affidavit is the fact that Mr. Wilder apparently believes that his use of personal funds absolves him of campaign reporting requirements. I would like to point out that by reviewing Mr. Wilder's campaign financial reports for 2019 and 2021, one will find contributions from donors for amounts as small as $5, $10, and $20. There were also contributions of $1,000. Those contributions came from personal funds of donors. Donors contribute personal funds to affect the outcome of an election, and those contributions are reported. Yet in this case, Mr. Wilder apparently believes his financial expense supporting Melissa Owens from his personal funds does not have to be reported. Mr. Wilder should have disclosed his financial assistance in his effort to promote the election of Mrs. Melissa Owens. This could have been accomplished either by listing it as an in-kind contribution or an independent expenditure on Form 30A. I do not know how many of you here remember radio news broadcaster named Paul Harvey. He began his news commentary in 1951. My maternal grandfather introduced me to Paul Harvey's radio broadcasts in the 50s and 60s when I was a child. In 1976, Paul Harvey began a separate program called The Rest of the Story. Given that the endorsement letter is wholly about Melissa Owens, reminds me that there is very much a rest of the story to be told here. First, I should state that in Melissa Owens' 2023 campaign, her husband, Nick Owens, was her treasurer. The rest of the story here is that in the last 2 months, it has come to light that Mr. Owens has been indicted in Stark County for the theft of $560,000, and that both Melissa and Nick Owens have filed a civil lawsuit against each of them in Stark County Common Pleas Court for the return of that $560,000. Laws have consequences, and I do hope this commission will find Mr. Wilder violated Ohio campaign finance laws, as I have alleged in my complaint. And I do have information regarding the last part of my comments here. Thank you very much.
Mr. Osborne, are there any questions for the members? Commission? If not, we will hear from
Mr. John.
Mr. Johnson. Come on,
Mr. John.
John. That's okay. Thank you.
Thank you, members of the commission, executive director. If I may approach, I have a notice of appearance for the commission.
Give that to, you can give that to Chris.
Thank you so much. Thank you. Mr. Osborne.
Oh, thank you.
And members of the commission, you'll have to forgive me for stating your honor over and over again. Old habits die hard. So my apologies ahead of time. First and foremost, Michael John on behalf of Placus Manus in Canton, Ohio. I'm representing Mayor Wilder and the committee to elect Steve Wilder. Before I go into any kind of response to Mr. Osborne's comments today, I want to first thank you all for being here. I know that on behalf of my client, Mr. Wilder, he appreciates being heard today. And while we vehemently disagree with Mr. Osborne's allegations, certainly we appreciate that you're giving us the time to speak with you. And Mr. Wilder will comply with anything that the commission requires him to do. So ladies and gentlemen, we are here today because Mr. Wilder used personal funds from his personal bank account that he shares with his wife to help candidate Melissa Owens. Ladies and gentlemen, as the commission knows, a thorough review or even a cursory review of 35 Revised Code 351710 lists campaign committees, political action committees, legislative campaign funds, political parties, and political contributing entities as those who are required to file those types of financial disclosure forms after a contribution is made. The human being who used his personal funds, Steve Wilder, is not any of those things. He's just not. And ladies and gentlemen, we take issue with Mr. Osborne's interpretation of the Freeman matter because in Freeman, the Ohio Election Commission actually found Mr. Freeman and his campaign committee had violated 35-17-10 and 35-17-13. The exact same revised code provisions that Mr. Osborne's complaint alleges. Now, the 10th District Court of Appeals found that it was error for the commission to find both Freeman and his campaign committee had violated 35-17-10 and 13. And it was upheld because obviously Freeman, who was responsible for his campaign committee, was responsible for the penalty. This case is completely different, ladies and gentlemen. In fact, in Freeman, and I'm quoting here, in Freeman, the 10th District Court of Appeals claimed a campaign committee is more akin to a business organization, such as a corporation, rather than a natural life. The 10th District went on to say that, as we cited in our response, that the campaign committee is the responsible party under revised code 35-17-10 and 35-17-13. Well, ladies and gentlemen, seated behind you is Mayor Wilder. He's not an entity. He's not the corporation. He's not a campaign committee. He is the natural life. Again, these were personal funds out of an account that he used with his wife to help Melissa Owens, another candidate in North Canton. These are not funds that he was required to disclose. And in fact, we would submit to you that the candidate, the campaign committee to elect Melissa Owens, the onus, the responsibility is on her to make those disclosures because she is the one who received those in-kind contributions. Ladies and gentlemen, we ask that you find that Mr. Osborne has not met his burden. We ask that you find Mr. Osborne is unable to show the commission that the candidate Steve Wilder did not violate revised code 35-17-10, that the campaign committee to elect Steve Wilder did not violate revised code 35-17-10. And that's in part because of the fact that Steve Wilder used his own personal funds for this to Melissa Owens, and in part because none of these funds ever touched hands, or ever transmitted, ladies and gentlemen, to the campaign committee to elect Steve Wilder. They were personal funds coming out of a personal checking account that, quite frankly, his campaign committee would have no idea about because they were never dispersed to his campaign committee. So, ladies and gentlemen, for those reasons, and for the reason that Mayor Steve Wilder cannot act as a campaign committee where he has already authorized a separate campaign committee for his candidacy, we ask that you find that Mayor Wilder and the campaign committee to elect Mayor Wilder did not violate revised code 35-17-10. Thank you.
Thank you, Mr. John. Are there any questions of the witness? Thank you very much. Yes, go right ahead.
Yeah, I do have a couple of questions. Just want to make sure it's the appropriate time. Thank you for being here.
Thank you.
Could you tell me if Mayor Wilder at any time coordinated with candidate Owens? I mean, did the mayor, let the candidate know, hey, I'm going to do a mailer for you? Are you aware of that?
Well, I am aware that Mayor Wilder's quote that in the letter that he sent out was actually used on Melissa Owens's mailer. And she actually quotes at the end, and it's actually in Mr. Osborne's initial complaint. It is quoted, and she kind of jumbled some of the sentences around so it doesn't read verbatim how his letter was written. But she actually quotes Mayor Wilder and has a picture shaking hands with Mayor Wilder. And so our argument to you, the commission, is that it was absolutely something that they did in tandem, in cooperation with each other. She would not have not known, for lack of better terms, of Mayor Wilder's intention if she didn't use the quote in Mayor Wilder's mailing and then subsequently show a picture of them to obviously supporting one another.
Thank you. And I actually wrote a couple of notes, and one of the notes, the questions that I asked myself is, should candidate Owens have filed, reflected this as an in-kind contribution to her campaign? And that would have required her to seek the information from Mayor Owens. I'm sorry, not Mayor Owens, Mayor Wilder.
Sure.
On the cost of this mailing.
Sure.
And so I do have some concerns, Madam Chair, about, this particular issue. I mean, there was around $1,000 mailing that occurred. Someone didn't report it. It was very clear that, they were being done in close relationship with one another, which is their right to do. And then the other comment I have for the complainant was simply, he brought up, about the number of mail pieces. And I view that as kind of irrelevant because we don't know why they chose the data and how they chose it. And so saying that, we mailed to the voters of a precinct does not necessarily say, well, we mailed every voter of the precinct. So that is a little moot to me, but I may have a few more questions, but that's it for me. Thank you, Madam Chair.
Thank you very much. Are there any other questions from the members of the commission? If not, thank you, Mr. John.
Thank you.
Mr. Richter.
I share some of the, I guess I'd say, concerns that Mr. Caraway expressed. My recommendation for no violation is the fact that these were personal funds made by the candidate individually and not through the campaign committee. And so that's the basis for my recommendation under this set of circumstances to find a violation. Mr. Wilder may have been obligated to file an independent expenditures report. Ms. Owens may have been obligated to file, excuse me, or included a campaign finance report. And then an in-kind contribution if she worked with Mr. Wilder on this. But the issues that we have before us is whether there was a violation of 351710, and I don't see that here. I'll be glad to answer any other questions the commission may have.
Are there any questions of our executive director, Mr. Caraway?
Thank you, Madam Chair. Mr. Richter, could you walk us through your recommendation? Obviously, the violation, you don't see a violation in this statute. And let me read in part. The personal expenses of a candidate shall be paid for by the candidate from the candidate's personal funds and shall not be considered as a contribution by an expenditure, et cetera. So in this particular case, this is not candidate Owens. This is, you see what I'm saying? So
Not candidate Wilder? Or
yeah, so obviously the mailer was benefiting the gentlelady running for council.
correct.
And so of course it wouldn't apply to this because it's her campaign committee, not Mr. Wilder. I'm not making any sense, am I?
Well, no,
Okay.
but that's correct. I mean, the submission by from Mr. Wilder that, showed the personal check that he wrote for the mailer essentially was out of his personal account. It wasn't out of a campaign account. So I'm trying to think of how I commented on this otherwise when asked questions about it. Had it been done through the campaign, there's certainly no problem with doing that. And potentially would have saved himself the obligation to represent himself in this case. But he has every ability to act as an individual citizen, and circulate the materials that he did outside of his campaign, because there was no campaign disclaimer on the literature. There was no other campaign identification there. And so that's the basis for my recommendation here, is that the statute we have before us has not been violated. I don't believe.
Follow up, please.
Go right ahead.
Mr. Richter, does it concern you that the mayor was also a candidate for reelection in that same cycle? Though unopposed.
Right.
An active candidate who signed the letter as mayor. Clearly that's his title and I would have expected him to use the title mayor.
Right.
But is it, concern you at all that he was an active candidate for reelection himself? And so one could argue, I remember the AFTAB matter that we had last fall in Cincinnati. There was an argument made, did he also benefit in some way from sending out that letter from personal funds as a candidate for mayor?
I guess there's certainly that possibility. But again, with in this particular case, as we see, where the check came from essentially, and how the payment was made, an individual, as I just said, I got kind of stammering over myself. I think he could have saved himself a lot of trouble had he just done this out of his campaign committee, put his disclaimer on it, circulated it that way and done so. But that doesn't mean that he can't do it. He can't do what he did here. I think he just caused himself more problems. In my opinion, he caused himself more problems by doing it in the manner in which he did.
Thank you, Madam Chair.
Thank you. Other questions? If not, is there a motion?
I'd move to accept the executive director's recommendation.
Is there a second?
I'll second that.
Been moved and properly second. Are there any questions? If not, all in favor say aye.
Aye.
All opposed?
Nay.
That's been approved by a vote of 5-1. Next case, we're going to this one next?
Yep.
Okay, next case is number 2024 R-386. This is Regina McManus et al.
And also,
And thank you very much. Campbell versus McManus et al. And that's 2024 G-028.
Madam Chair, members of the commission, I am recommending that we consolidate these two cases because they essentially cover the same factual set of circumstances, even though they came from two different places. 2024 R came from the County Board of Elections, asserting various violations by, Ms. McManus, Mr. Minor, the Presidential Cigar Club, and TCR Grassroots PAC, in terms of materials that were paid for, circulated during the primary election. Those same issues were a part of 2024 G-028 that the commission is addressing here today. We received responses. I've circulated them to you so that you all had the opportunity to review them. There were a variety of allegations that were identified in the respective complaints. My recommendation, and I've synopsized the responses. Mr. Minor essentially indicated he was just buying labels from the county. Nothing improper in doing so. Ms. McManus gave a little bit more of a broad statement concerning both her actions, the actions of, quote, the Cigar Club and what it did, and TCR Grassroots PAC, based on the materials that have been submitted. My recommendation, after consolidating these two cases, is to find no violation against Ms. McManus, Mr. Minor, and the Trumbull County Presidential Cigar Club, but to find a violation against the TCR Grassroots PAC, but for good cause not impose a fine. We received the responses from the respondent. It doesn't look like the respondent is here. But Ms. Campbell, the complainant in case number 2024 G-028 is here. If the commission would like to hear from her further, we could do so. If the commission has any other questions for me, certainly feel free to go ahead and ask whatever you wish as it relates to my input on this matter.
Madam Chair, I have a question for Mr. Richter.
Go right ahead.
Mr. Richter, on the second part, finding a violation, could you be more specific with respect to the violation?
Yeah, I mean, this is kind of I don't know if I want to say an odd situation. I'll phrase it that way in terms of the TCR Grassroots PAC filed its statement of organization with the FEC and created itself as a federal PAC. Which there's, they can do that. There's no problem with doing that. And as a federal PAC, it has an ability to enter into Ohio. Obviously, she's from Ohio, but oftentimes, federal PACs are literally from all over the country. And they have an ability to participate in Ohio elections as long as they file a copy of that statement of organization generally speaking, it's with the Secretary of State's office. And that was done here. I think the comments in the response reflect that the PAC was created FEC wise March 11th, 2024, excuse me. And then they filed their statement of organization with the Secretary of State's office on March 29th, I think is what the documentation all establishes. And that, those activities certainly comply with, or at least I'm assuming comply with the federal provisions. I try to remain blithely ignorant of a lot of the FEC rules, obligations. I'm aware of some of them. Here, obviously, you file a statement of organization and create a PAC. But under 3517-107, a PAC is obligated again to file a copy of its statement of organization with the Secretary before it takes any action in the state of Ohio. And then it can go ahead and take whatever action it wants to, make whatever expenditures, receive whatever contribution. In this particular case, though, to me, as I view it, while the federal PAC was created presumably properly under federal law, the filing of the statement of organization, which was not done until March 29th, was late because what the Ohio statute says is prior to making any such contributions, expenditure or independent expenditure, federal political committee shall register with the Secretary of State. Well, this was for the March 17th primary. I think it was March 17th. The slate cards, et cetera, were purchased prior to that. They were circulated prior to the primary election, but the statement of organization wasn't filed with the Secretary of State's office on March 29th. And so that's the basis for my recommendation to find a violation against that group. Essentially, it was for a late filing of the statement of organization.
All right, thank you. I just wanted to be clear on that. So essentially, they were 12 days late, and that's why you have a good cause violation.
Correct. At least 12 days late.
Thank you.
Are there any other questions of the executive director?
Madam Chair, quickly, Mr. Richter, part of my concern, I agree with your recommendation, although the good cause portion I probably do disagree with, simply because I view this as a more serious violation than I do, a candidate, and this is just me speaking, than a candidate not filing on time. There was very, very clear activity, weeks from the documents, not days, but weeks. And so my only comment would be that I do believe that we should impose a fine of at least $50 in the matter. So.
Okay. And I understand and respect that. I'm, this is a first time candidate first time PAC before I can go into all that kind of explanation. That's kind of where my recommendation comes from. I have to say, I did consider going beyond good cause, but kind of trying to be consistent with how we normally approach these is where I'm coming from. But I have no problem with you expressing your opinion there, and can't say that I don't disagree with it.
Any other questions of the executive director? If not, does anyone want to hear from our Mrs. Campbell, Ms. Campbell? And Ms. Campbell, you will be sworn in.
Right hand. You swear from to tell the truth, the whole truth, and nothing but the truth.
I do. So first of all, thank you for allowing me the opportunity to speak. And I have to agree with your statement that this went on weeks before. There was actually intent because these so-called slate cards were printed and they started mailing them out on February 20th. So we're looking at what, 5 weeks, 6 weeks. Okay. It wasn't until I sent out an email as an officer of the Republican Party to our central and executive committee, highlighting to people that this was not the party that did this. This does not represent the endorsed candidates or unendorsed candidates. And it wasn't until that email went out that they applied for the FEC. There has been intent for voter fraud from this person for going on 8 years now. She currently has a group called the Trumbull County Presidential Cigar Club, which is an LLC. This LLC has been holding fundraisers for 8 years. And you could correct me if I'm wrong, but my understanding is that an LLC cannot, under law, be a PCE, which this is. And I have evidence with me that shows that she has written checks out of this Presidential Cigar Club. She raises the money, takes in the money, and uses it to attend other candidates' functions for herself. Furthermore, this LLC, the Cigar Club, has held fundraisers for candidates and advertised to pay the money to her, to the Presidential Cigar Club. However, on a dual fundraiser for 2 different candidates, neither candidate received any money from this fundraiser. Nothing showed up on their campaign finance reports. When one of the candidates called me and said, you know, he had no money to run the campaign, I said, you just had a fundraiser, where's your money? She never gave us any. There have been Christmas parties 8 years in a row where she charges attendance. Then in return, at this so-called PAC headquarters, which also is being used as kind of like a shadow of the Republican Party, Republican candidate headquarters. She's advertising as if she is the Republican Party. I have evidence to all this. Furthermore, we are running the TCR Grassroots PAC, Republican Candidates Headquarters, Presidential Cigar Club, and McManus Strategies, all out of this one location. So if you're a PAC, you're not supposed to be working with candidates, whether it's an Ohio PAC or a federal PAC. There should be no candidates involved in a PAC. Actually, the attorney that filed the PAC on her behalf is actually a judicial candidate in the November election. This group, McManus and Jason Miner, after I called attention to the fact that, you know, to the Central and Executive Committee, that this was not a legitimate slate card. This was not sent out by the party. That is when they decided to file for the PAC. Now, in my email, I had pointed out to everyone that, and I showed a copy, attached a copy, this was not registered with the Secretary of State. There was no PAC registered, which is why they moved to file federal, because I had already shown everyone that this didn't exist. So now they filed on, I believe it was the 11th or 16th, for the federal PAC, that tried to backdate it to February 1st before they started collecting and doing all this. We're looking at over $1,000 expenditure. The labels alone that they picked up, 1,140 labels. That's how many mailings were done. That's printing, postage, price of the labels. Not to mention the fact that these people stood outside the Board of Elections during early voting, holding up signs saying Republican sample ballots and passing these out. This is an attempt. This is a clear violation. This is election fraud. Once these reports were filed, the statement of organization, they realized now that they had to file with the Secretary of State. So 2 weeks later, now they file with the Secretary of State. However, I have copies of the reports that they filed. And I could tell you that when they filed with the FEC, after they received 2 notices, the 2 notices were April 30th and May 16th of 24. They were sent 2 notices that they needed to file a statement, a finance statement. On June 3rd, they filed one with the FEC saying that they had taken in $1,543. On July 15th, they filed one now saying it was only $1,480. With the Secretary of State, they filed one showing $0. And I do have copies of all that. So there is no accountability here. This was never intended to be brought forward. And I'll tell you how I know that, because this was done in the election prior. The November election prior to this primary, it was done to another candidate by a fake PAC. And that is why, as a board, I serve on the Board of Elections and as a member of the Republican Party, an officer. That is why we decided that we had to put a stop to this. This has been going on for 8 years. There is no accountability. Even if these things were paid for by themselves, receipts should accompany reports. There should be accuracy. I deal with campaign finance all the time. There has to be accuracy. Everything has to balance. You cannot show $0 to the Secretary of State and 2 different amounts on 2 different reports for the FEC. The fact of the matter is there are no receipts. This was never intended to be called into question. This was just going to be done like it was in the prior election, and it was going to get erased and nobody was going to do anything. And the people of Trumbull County have had enough. This has been election interference for 8 years. It's time to put a stop to this. To this date, as of yesterday, there is still no designation of treasurer on file with Trumbull County Board of Elections. That is also required. There have been no reports and no designation of treasurer, because McManus she is the sole officer for all these entities. McManus Strategies, which is not is registered business with the state. The TCR PAC, she holds all the offices. Cigar Club, she holds all the offices. President, Vice President, Treasurer, Secretary. It's all one person. Okay. There have been no reports showing rent, utilities, because this building is still going. This is still being run as a shadow to the Republican Party. No rent, no utilities, but yet they're still operating. No money's claimed. So we have an LLC acting as a PCE, and I do have evidence that she did write checks out of there to candidates for her own attendance to their fundraisers. There have been no reports filed on those. So I believe this is more than just a late filing. There was never intent to file this, and had I not sent an email out to the Central and Executive Committee, nothing would have been filed. It was only filed after I called it into question. and after complaints were filed at the Board of Elections by other candidates. This is election fraud. This is not a late filing of a few days or 5 weeks. Now, there was no intent to file this because this has been going on for 8 years. And her response to the Vindicator is, it's my the Tribune, it's my First Amendment right. I have free speech. And I will not let these people stifle me. This is what we have dealt with for the past 8 years as a board and as a party. We owe it to the candidates that filed complaints with the board, and I owe it to the Republican Party to put a stop to this once and for all. This has got to be stopped once and for all. This was willfully and intentionally violation and misuse of campaign finance, of registration. It is voter fraud. It is voter fraud. So I implore you to make the right decision. Let's put a stop to this, because I could tell you that July of this year at the Trumbull County Fair, it occurred again. Even after complaints have been filed with the Secretary of State, the OEC, and the FEC, it was done again at the Trumbull County Fair this year. So it's not going to stop unless something is done. Thank you.
Thank you, Ms. Campbell. Any questions of Ms. Campbell?
Madam Chair,
Yes.
I'm sorry.
Commissioner Lyle, go right ahead.
Yeah, I would like to see the checks that she has. I don't believe we were provided with checks, were we? Mr. Richter? I don't.
We were only provided with what was included, anything that was included with the initial complaint is what I circulated.
Right.
Anything else, that has been discussed has not been presented, otherwise presented to the commission so far.
Ma'am, if you had copies of the slate cards.
I do.
Did we
So
see?
the slate card, I think, was included.
I remember seeing the slate card.
I think it was originally, I think it was, Commissioner, there were many files. That's, but I remember seeing a slate card.
Okay, then I missed it. That's on me, but I would like to see it. Can I see it? Yeah.
Mr.
certainly.
Richter's going to pass
That's
this
it.
down.
Yeah.
Can you pass that down to Mr.
And
Lyon?
there's also the mailing labels.
I think our scans were really bad, Commissioner. That's probably why they were hard to read.
Well, I appreciate you covering for me, but somehow I missed it amongst all the paperwork. Thank you.
Any other questions, Mr. Lyle?
No, just I would like to see the checks, also that she said she had.
Did you have checks that you talked about? Did you want to present?
No, I have copies of the reports of the Secretary of State, the FEC, the reports showing the discrepancies in the amounts. I have copies of those. No, her checks, I have no access to those.
Oh, okay.
But as I said, there's
Because she hasn't filed a report
correct,
with the BOE or.
correct, correct. There's no documentation. And, like I said, this started back in January of 2024. The office is still in operation. There is rent, utilities, internet, things like that. Nothing's been claimed.
Mr. Kolke, do you have some questions?
So I have a question for the executive director also, and maybe another one for Ms. Campbell. So this is not a 501c4, is it? The TPC, the,
TCR grant.
CR Grassroots PAC is not, no, it's a federal PAC.
it's a federal PAC and but it was created, one of the documents you presented says it was created with the Secretary of State in 2018.
That is the Cigar Club,
That's
The Cigar Club.
Trumbull County Republican Presidential Cigar Club.
Okay. And the PAC was formed not until March of
Till,
2020.
I believe it was March 16th.
Okay. And now my other question was similar to what Mr. Lau says. So, you know, there's accusations that it was made in previous election, but we have the evidence that I think we presented you, the only one is concerning the March 2024.
I do have evidence of the presidential cigar club going on for 8 years. I do have it with me, but no, again, no reports.
No reports. Okay. Thank you.
Madam Chair.
Commissioner Caraway.
If I may, thank you. So my question is to the executive director, two things. First, I think there's a lot to unpack here, and so I would encourage us to start thinking about setting the matter for a full hearing, because there are a lot of moving parts. But the other question I have for Mr. Richter, Ms. Campbell said that no reports have been filed with Trumbull County Board of Elections, which, by the way, would give you access to see receipts and checks, and the
Correct.
same for if there was
Correct.
some state filings. Could you tell us, Mr. Richter, verify that that is in fact, or should be a requirement of this PAC who's doing business locally, so to speak, with local candidates? Or if they file with the secretary's office, would that be sufficient? Because clearly there's election activity taking place.
Federal, I mean, certainly I can understand the whole concept or the concerns with regard to local candidates, but a federal PAC is only obligated, they could file a statement with the local county, but they were only obligated to file with, with the Secretary of State's office, with some office, and that's been done here. And so
The
they're,
expenditures,
I'm sorry.
the expenditures, have they, in this material, because I couldn't find it, have expenditures?
The only thing you're obligated, and I don't know if the secretary, well, the one report that I saw that the secretary has acknowledged receiving, reflected an in-kind contribution to the campaign committee, and to the PAC, I should say, not campaign. That wouldn't necessarily be an expenditure, by the PAC, obviously, it's an in-kind contribution to the PAC. But they're only obligated to file with the Secretary of State's office. There isn't an obligation to file locally, no.
Okay,
Now, the secretary, if I may, Secretary of State's office told me that and the Board of Elections has told me that they are required to at least register the PAC with the Board of Elections and have a designation of treasurer plat.
Which PAC are you talking about?
This TCR grassroots.
If they're a federal PAC, there's no obligation on them to file anything locally, of which I'm aware.
Okay, so the board gave me false
I mean, they
information.
could, but if they created as a federal
That would be
PAC,
the Secretary of State's requirements.
if they've created themselves as a federal PAC, they're existing as a federal PAC, then they've got an obligation, like I said, to file a statement of organization before they conduct any activities local or here in the state, or
Mhm.
locally in your case. But I'm not aware of any obligation on them to file anything locally under that set of circumstances.
so are you suggesting that, Madam Chair, sorry, Mr. Richter, are you suggesting that filing an FEC designation takes away the requirement to disclose expenditures and contributions at the county or state level?
Well, they're obligated to file them with the federal level.
Right,
Yes. And
right.
then when they file the statement of organization with the Secretary's office, their Ohio activity is expected to be submitted to the Secretary's office. When they file, let's say you've got a post-election FEC report. At the same time that report is filed with the FEC, the expectation is that report is at least date stamped to be sent to the Secretary's office in the same time frame.
Okay.
So that's the obligation that they have, is filing copies of their Ohio activity. Because, this is a much different circumstance than you would normally think of in terms of federal PAC. If you've got a federal PAC that conducts activities all over the country, maybe their campaign finance report is this thick, but it includes activities in named states, whatever. But their Ohio activity is only that thick. That's all they're obligated to file with the Secretary of State's office, is the Ohio activity, contributions and expenditures.
Thank you.
Any other questions, Mr.?
Madam Chair,
One
go ahead.
second,
Go
one
ahead.
second. You go ahead. One second, Mr. Lyle. Mr. Colby.
Yeah, just to follow up to that, so the documents we got with the FEC showed showed income of $1,500 and some in March. So what you just said, according to their activity, there should be another FEC report at some point in the future if there was Ohio activity that is, well, any activity that would be shown on the FEC, but then it would be reported to the Secretary of State if there was activity in Ohio.
The activity would be reported to the Secretary's office because that's where, essentially, that's where they're registered.
And do we know when that, so this one was, I think, through March.
March 29th is when they originally submitted their statement of organization.
Do we know when the next deadline on an FEC level would
Not off the top of my head. No.
be? Okay, thank you.
Yes, I
Mr.
mentioned-
Lyle.
Thank you, Madam Chair. Mr. Richter, I'm trying to remember, we had a similar case to this, I believe. Not totally, but at least with respect to the slate cards in Cincinnati. City of Cincinnati, as I recall, and your members can help me pick my brain on this. I don't recall the actual case, but I do remember it was the Democratic Party that there was an issue with the Democratic Party and folks that were not actually endorsed by the party, and Democrats were handing out similar type slate cards. Do people remember that case?
Vaguely, yes.
I'm trying to remember how we ruled on that case.
That was, my recollection is though, there was I'd say a more direct reference to the Hamilton County Democratic Party involved in the disclaimer than here is one difference that I can, as I recall. But yeah, it was filed, but that all involved local PACs though, too. There wasn't a federal PAC involved.
No, I understand that. I'm just
It was a
talking
local
with
organization.
respect to at this time. Let me digress a minute. I agree with Mr. Carroll where there's so many moving parts here. I think we probably should have a hearing, but in this specific instance, I was trying to recall how we ruled on the slate cards, because I think it is a similar pattern. I mean, it was one basically saying they were endorsed by the Democratic Party. Democratic Party was saying, no, that's not the case. They had a slate card that they made up, but I just don't recall at this time. I mean, it was probably, 300 cases ago. But I would like to kind of look at that case too, going back to Mr. Caraway's point about having a hearing. But anyway, that's, just was curious if you recalled that case.
I'm about 95% sure that not only was the slate card more direct reference,
Okay.
but the background and the logos were very similar to the actual party. However, we ruled, again, I'm 95% sure, we determined as a commission that despite all those similarities, it was still distinct enough that, I forget who was respondent, we determined that the slate card was okay.
Okay.
And I remember it because I thought it was too similar and I voted the other way.
Okay.
And again, I'm 95% sure, but I could be wrong. I did have a question, Madam Chair, for this directory. So if a group registers as a federal PAC and does 100% of their activity in Ohio, and don't know if that's the case here or not, I have a sense it's not 100%, it's pretty close. We've talked in many cases about the definition of a PAC and the requirements of a PAC. Is there a statute where it says, you're doing the majority of or all of your activity in Ohio, so you now need to also register as an Ohio PAC?
If there is such a thing, I'm not aware of it. No, once once you establish yourself as a federal PAC, you have committed yourself to making filings with the FEC, and that's your primary focus for your filing obligations is with the Federal Elections Commission. And again, when you look at the statutes that incorporate, I don't know exactly how many, but Ohio is one of the rare states that places this kind of an obligation on federal PACs in terms of also having an obligation to file essentially locally with the state of Ohio. But that's, those are the obligations that you have if you create a federal PAC. Even, I would say, even if you're a 100% local, in terms of only acting within the state of Ohio, once you create that federal PAC, you're a federal PAC. You're subject to the federal filing obligations, and your only obligation is under 3517-107 to file whatever you do in Ohio with the Secretary of State's office.
So you wouldn't have to look at the other statutes separately and then comply with it as well and say, we fit both buckets. You've kind of basically got to get a jail-free card because you filed federally, is the interpretation.
You create yourself as a federal PAC, you are a federal PAC. That's your direct obligation is to the FEC, and it's secondary to the state of Ohio.
Okay, thank you.
Just for clarification, I guess that sounds strange to me, that all of your activity is local, but you want to organize as a federal PAC and you have no federal candidates that you're supporting. You're only supporting local candidates or not in this case. It's just a way to skirt. That's just what I feel right now.
Does it?
No, it doesn't feel right. And it does sound like it's a good piece of legislation for members of the General Assembly and even members of Congress to take a look at, because I'm sure we're not the only state that's dealing with something like this, that you organize as a federal PAC, you just file, and they're not interested in really candidates that are not federal candidates. They're really only interested in what their obligations are to the American electorate at the federal level. And so if all of your business is at the local level, the state of Ohio level, you basically can do what you want to do. It just doesn't feel right. And I think both gentlemen are probably correct. We probably need to see if the commission is willing to go for a full hearing. Yes.
Madam Chair, just a question along those lines, and my instinct is to agree as it relates to a full hearing. I do want to distinguish between the seriousness of the allegations, they are serious, and what is within both the four corners of the complaint and our jurisdiction. And really that, relates to the last hearing as well. The reason we decided the way we did is because we were limited to the four corners of the complaint and address that specific issue. So I would ask the executive director, given those thoughts, would you be inclined to extend the matter to full hearing? Are enough of these allegations within both four corners of the complaint and our jurisdiction to justify going forward with the full hearing?
Yeah, if the commission decides it wants to set for a full hearing, I don't see that as a problem. Let's put it that way. I would think that what we have before us certainly could lead to interesting information aside from what we have already received in the documents that have been presented to us.
Good. And, cut to the chase and to be as efficient as we can with everyone's time. I would move, if necessary, that we would extend the matter to a full hearing.
Second.
It's been moved and properly second. Are there any questions of motion? If not, all in favor?
Aye.
All opposed? We have an approval of 6-0. Thank you. Thank you, Ms. Campbell.
Thank you.
And Mr. Director, Madam Chair, just for Ms. Campbell, we may want to explain to them what the action that we just took in case you're not aware of what our process is here, so.
Yeah, you'll
Mr.
be
Richter.
notified of when the matter will be set for hearing at some point in the future.
Okay.
Okay.
It'll be before the same board.
It will be before this elections commission, yes. The personnel makeup of the commission at that point may be slightly different. But yes.
All right. Thank you for your time.
Thank you.
Will the petitioner have the ability to submit additional documentation?
Yeah, that's what the hearing is all about. Submitting to us all the evidence that is necessary to establish. Obviously the complainants will be given the opportunity to establish that there's been a violation
And
and
I
whatever
apologize for interfering.
whatever
I was really
information is
just here
necessary
from
to do
World
that.
Report.
And the respondent will be given every opportunity to present, counter evidence that it believes is appropriate to defend its position.
Thank you.
And Mr. Richter, correct me if I'm wrong, the parties also have the opportunity to seek discovery,
Correct.
correct? So you
Kind
would
of
have,
like a trial, almost a mini trial.
Yeah, I would, if I could, Madam Chair, encourage you to speak with counsel if necessary, but as Commissioner said, yeah. So evidence, witnesses, opening, closing, very similar to court proceeding.
Okay. This is my counsel. So
Thank you all very much.
thank you very much.
One thing that I will add before we go any further, I was recommending, and we never got around to consolidating these two matters. Now have decided to set something for a more full and complete hearing. Did we want to consolidate these two matters for hearing purposes?
Yes, and I would so move.
Okay.
It's been moved. Is there a second?
I'll second that.
It's been moved and properly second. All in favor, say aye.
Aye.
Opposed? That's been approved by a vote of 6-0. Thank you all.
Thank you.
Next,
Thank you.
you're welcome. Next, we're gonna move on to group recommendations. The first one is case number 2024 R-039, and this has been withdrawn by the Board of Elections. We don't have to do anything.
Your mere mentioning of it and acknowledging it is all that was necessary.
Thank you very much, Mr. Richter. The next two cases, 2023 R-542 and 2023 S-054. These are being dismissed for failure of
That's
service.
my recommendation. We have had repeated notices sent out and they've all come back undeliverable. And confirmation, at least as it relates to the first matter, the Owens Williams matter, the Board of Elections has indicated they have had issues contacting that person as well. So my recommendation is to dismiss those matters for failing to serve.
And we don't have to take a vote on this.
No, yes,
Thank
I
you
would
very much.
recommend it. I would recommend a motion and action.
Thank you very much. Is there a motion?
So moved.
It's been moved. Is there a second?
Second.
It's been moved and properly second. All in favor, say aye.
Aye.
All opposed? That's been supported by a vote of 6-0. Next is to declare terminated and dismiss complaint at the request of the Board of Elections. This is case number 2024 R-117.
Mr. Cole has a lengthy history before the commission and I went back and forth with the Board of Elections, and they indicated, some of the efforts that they have undertaken to, be in contact with Mr. Cole. He said he filed a designation in 2013 to run for school board and has not filed anything subsequent. He had any number of referrals to the commission previously. The board talked about the various times when Mr. Cole has changed addresses that they've tried to reach, and he's changed voter registration. They've not been able to do so. They even reached out at some point. I'm not sure whether it was to a local county or to a state incarceration institution. We're not able to reach him in any of those places. And so they're asking if we would declare that committee terminated and then subsequently dismiss the complaint. And so that's the recommendation I am making based on the information I've gotten back from the Board of Elections.
Are there any questions of the executive director?
Madam Chair, I have
Yes.
a motion.
It's been moved. Is there a second?
Second.
It's been moved and properly second. All in favor, say aye.
Aye.
All opposed?
Nay.
Okay, it's been approved by a vote of 5-1. Thank you. Next, these are good cause cases. The first is 2023, all are 2023R-579, 2024R-032, and 2024R-063. Mr. Executive Director.
First and third items in this list, they submitted a response. They were less than 2 weeks late in submitting their report. And so that's the basis for my recommendation there. As it relates to item number 35, we received the reports have been filed. They were filed beyond about a 2-week period, about 2 or 3 months late, as I recall. The response that we received was from the wife of the candidate who is now deceased, who explained the various physical limitations that the candidate had placed on him during the election cycle and during the reporting period. And that was the primary reason why the reports were not timely filed. But they've been filed. A response was submitted. And so my recommendation is to find good cause in these 3 matters. I'll be glad to answer the questions the commission may have.
Any questions of the Executive Director? If not, is there a motion?
So moved.
It's been moved. Is there a second?
Second.
It's been moved and properly second. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. Next are the $50 fine cases. The first one is 2024R-024. Second is 2024R-034. Mr. Executive Director.
The reports have been filed. They were filed within about 10 days to 2 weeks. A response was submitted giving an explanation. And so my recommendation in each of these matters, or I'm sorry, they were filed beyond 10 days to 2 weeks. My recommendation is to find a violation, impose a fine of $50.
Any questions of the Executive Director? If not, is there a motion?
So moved.
It's been moved. Is there a second?
Second.
It's been moved and properly second. All in favor, say aye.
Aye.
Opposed? That's been approved by a vote of 6-0. Next are the $100 fine. All of these are, first 4 cases, 2023R-553-566-599-0-603. And then the remaining are 2024R -002, -007, -043, -056, -084, and -091. Mr. Executive Director.
These are all matters where the report has been filed. No response has been submitted to the commission. And so not having a better understanding of why the reports were not timely filed, my recommendation is to find a violation and impose a fine of $100.
Are there any questions of the Executive Director? Is there a motion?
Oh, second.
Everybody's jumping it out.
Double move. and
Just
double second.
decide how you want to journalize that.
Yes.
Can we get a clarification for the record on who's going to be noted as the?
I'm recommending I heard Mr. Kirschner first, and I heard Mr. Caraway first as it relates to seconding the motion.
Thank you.
With all due respect to Mr. Lyle.
Aye. No problem.
It's been moved and properly second. Did we already do the vote?
No, we have not.
All in favor?
Aye.
All opposed? That's been approved by a vote of 6-0. Next is the candidate cases. Find a violation and impose a fine of $100. These are cases 2024R-065 and 2024R-071.
Madam Chair, my members of the commission, I'm recommending that we consolidate these because these 2 ran as a combined campaign committee. Epley and Sanders, I can't remember, they were running for school boards. They were running for North Randall Council, but they ran together. The report has been filed with the Board of Elections. No response was submitted. And so my recommendation is to find a violation, impose a fine of $100.
Are there any questions of the Executive Director? If not, is there a motion?
So moved.
It's been moved. Is there a second?
Second.
Been moved and properly second. All in favor, say aye.
Aye.
All opposed? Been approved by a vote of 6-0. Next, the $150 fine category. First one is 2023R-585. The next 3 are 2024R-051, -054 and -055. Mr. Executive Director.
These matters all have some form or another, the reports have been filed, first off. Some we've received responses on, others we haven't. The difference in the recommendation on each is that there were prior matters outstanding. The first, item 16 and item 50, the commission had prior matters before us where the commission found a violation, but good cause. Now they're back again, so I'm recommending $150 fine there. As it relates to items number 46 and 49, there have been multiple cases before the commission previously. And so I'm recommending that the commission find a violation, impose a fine of $150. I will mention item number 46, where I think there's three subsequent matters. The candidate has made payments on all the outstanding fine amounts. She gave an explanation this time around that included a variety of health-related issues. Originally, before I had a response, I was looking at imposing a fine of $250. I marked it down to $150 based on the nature of the response. But I just thought I'd mention that in case the commission wants to give her any further accommodation as it relates to the circumstances under which she was exposed before getting around to filing a report. Sorry, I'm stumbling over myself there.
Are there any questions of the Executive Director? Go ahead, Mr. Polk.
Yeah, just because on the ICW for case number 54, I believe it says a $200 fine. Is that the one you were just?
No, I hold on a second.
Ms. Stafford.
Okay.
Chris, I'm referring to the Chris.
Chandlewitz.
It's.
I changed that at the last minute,
Okay.
based on the submission that he made and the fact that there was a fine outstanding, but I decided to put it down to $150.
Thank you.
Any other questions of the Executive Director? If not, is there a motion?
I'll move. So move.
Okay, it's been moved by Mr. Quokey. Is there a second?
Second.
Seconded by Mr. Lyle. All in favor?
Aye.
All opposed? That's been approved by a vote of 6-0. Next, $200 fine. This is case number 2023R-555. Mr. Richter.
The report's been filed, no response was submitted. There was a prior violation found against this gentleman, which $50 fine was imposed. That fine has not been paid, so that's why I'm recommending that we find a violation, impose a fine of $200 here.
Any questions? If not, is there a motion?
So moved.
It's been moved by Mr. Lyle. Is there a second?
Second.
Been seconded by Mr. Knight. All in favor?
Aye.
All opposed? That's been approved by a vote of 6-0. Next is case number 2023R-586. This is reconsider case number 2023R-383. Vacate the previous finding and find a violation and impose a fine of $200. Mr. Richter?
This particular gentleman has prior matters before the commission. We found violation of good cause 2021 R-281. And then we consolidated a couple of cases that we decided just this last August. When reports were not yet filed, we imposed a per diem fine. Notice has not yet been sent on that because we just approved the minutes today. But now the reports have all been filed. They did so right around the time that we were meeting on the last matter, or did not reflect that at the time. No response was submitted, and so my recommendation here is, again, reconsidering the prior matters, consolidating them all together, finding a violation and imposing a $200 fine.
Are there any questions of Mr. Richter?
Madam Chair, also move.
Okay, it's been moved. Is there a second?
Second.
Been moved and properly second. All in favor, say aye.
Aye.
Opposed? That's been approved by a vote of 6-0. The next is a $250 fine. These are cases 2023 R-581 and 2024R-031. Mr. Richter.
There've been a number of prior cases involving Ms. Gowdy, the first item there. And so kind of the next level. And the fact that there was a fine that was paid, but there was also a fine that wasn't paid. And so you see my recommendation as it relates to that case. As it relates to the second item there, Ms. Granger. Again, there have been multiple prior violations in which some fines were paid, some fines were not. Fines were not paid. And so my recommendation in each of these matters is to find a violation, impose a fine of $250.
Are there any questions? If not, is there a motion?
So moved.
Yeah, okay, it's been moved by Mr. Quokey. Is there a second?
Second.
It's been seconded by Mr. Lyle. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. The next is a $300 fine, and the only case here is 2023 R-552. Mr. Richter.
The commission has had prior matters involving this individual. Fines have been imposed. They have not been paid back again. The report was filed. And so the maximum fine that can be imposed is $300. That's what I'm recommending in this particular case.
Are there any questions of the executive director?
Which one is this again?
This is case number 2023 R-552. It's number 8 on the agenda.
Thank you.
Any questions? If not, is there a motion?
So moved.
It's been moved by Mr. Knight. Is there a second?
Seconded.
Been second by Mr. Kirschner. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. The next is a $400 fine, and that is case number 2023 R-604.
The board has indicated this gentleman filed his reports. The referral was for a number of matters, semi-annual, and annual reports. Reports were filed in February. There have been prior matters in which the commission has made determinations and imposed fines. No action's been taken on those. So my recommendation here, which would encompass all those if he pays his fine back, would be to find a violation and impose a fine of $400.
Are there any questions of the executive director? If not, is there a motion?
Moved.
Been moved by Mr. Lyles. Is there a second?
I'll second.
It's been seconded by Mr. Caraway. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. Next, on page 4, we have $600 fine. This is case number 2023 R-020. Mr. Richter.
It's a case out of Cuyahoga County in which there are 4 prior matters. There have been some fines paid, others that have not been filed. The report was filed, was late, no response was submitted to the commission. And so my recommendation is to find a violation and impose a fine of $600.
Are there any questions of the executive director? If not, is there a motion?
So moved.
It's been moved by Mr. Kirschner. Is there a second?
Second.
Been seconded by Mr. Quokey. All in favor, say aye.
Aye.
All opposed? Been approved by a vote of 6-0. The next is to consolidate cases, find a violation, and impose a fine of $1,500. These are cases number 2023 R, both 2023 R. The first is -547. The second is 568. Mr. Richter.
Yeah, obviously, I'm recommending these matters be consolidated. There have been a number of prior cases submitted against this group. Fines have been imposed, some fines have been paid, others have not, and they are back again. The reports were due to be filed. One in particular was the semi-annual of 23. It was filed in August of 2024. They're back again. just based on the number, primarily the number of prior violations, and the outstanding matters, including these. I'm recommending that we find a violation and impose a fine of $1,500.
Are there any questions of the executive director?
Madam Chair, correct me if I'm wrong, I just asked the commissioner here, I feel like we've heard of the Stowe Firefighters Political Action Committee multiple times. Have they filed their reports, Mr. Richter? I mean,
Right at the moment, they're in compliance. The reports have been filed. They were filed toward the end of August.
any previous violations or amounts that we would have given to them have been paid?
Some have, 2016, we imposed a $450 fine, that was paid. 2014, we imposed a $200 fine, that was paid. It was just last year. Last August, we imposed a fine, that has not yet been paid. And now we're back here again.
Thank you.
Madam Chair,
Yes.
if I may interject here, I mean, typically, just knowing something about firefighters and unions, it seems to me that you can see, as Mr. Richter just said, they had fines, they paid a number of them up to 19, and then there's a void. Just my guess that probably people have retired. There's probably somebody got reelected, and probably they don't have a clue to what they're doing. So I guess the question is, do we continue to send it to the treasurer here? I don't know this, I'm speculating, but I do know how these groups work. It would seem to me, it says return receipts, somebody picked it up. I'm just thinking if there's a way we could call these folks, because they have paid their fines in the past. And, like I said, it just may be a matter of a new officer not having a clue about political action, but that's a hunch. I mean, firefighters, they're pretty easy to get a hold of. They're in the firehouse. So it would seem to me that we could reach out and say, hey, fellas.
Don't call 911.
Yeah. Just a thought,
Yeah.
just a
I might get
thought
some
on-
action now.
on some of these.
Just drop into the fire station.
And I, for transparency, I don't know any of these folks at all, so, but I just know how they operate.
Any other questions? Comments?
Should we offer the chance for reconsideration, give a reconsideration option, or Mr. Lyle, was that what you?
Yeah, I guess my concern, and we have this with many cases, we have this, but it's a question if we're actually getting through to the people that we need to get through to. I understand it says return receipt. I don't know if Aaron E. Packard, I don't know him from this wall, but he may or may not be gone, or it's just odd that, to me, when you look at the fact pattern, that they were late, but they paid for about 4 different times and then it stops.
Right.
So it seems to me something's going on there.
Is there a recommendation?
Well, I guess the recommendation would be, is there any way we can reach out to these folks?
I can try. I can also see if the board has any direction, has had any contact with anybody related here, because sometimes they will have, being more local, they'll have had opportunity to reach out or have discussions with folks when they've got situations like this. And obviously, recently they filed their report, so they've come into compliance. So I can always reach back out to the board.
That makes sense
Check
to
with
me,
them.
yeah, as the first line.
Yeah.
So that would be my recommendation, Madam Chair, that Mr. Richter reach out to, this is what, Summit County?
Yeah.
Summit County Board
And I guess
to make.
I understand that, but so what are we doing with the recommendation of the executive director that consolidated?
So there's been no indication that they have remedied this particular violation. So I would move to accept the recommendation and with a mind toward enforcing the fines, calling them.
That is my motion.
So if everyone understands the motion, is there a second?
Madam Chair, could you repeat the motion?
It's simply to accept the
To accept the
executive director.
recommendation.
Director's,
Okay, I'll second.
Okay, it's been moved and properly second. Any questions? If not, all in favor?
Aye.
All opposed? Nay. That's been approved by a vote of 5-1. The next group of cases, we're moving one. Yeah, that's
Yeah,
what
we're
I
gonna
was
deal
gonna
with
say.
that one first.
We're gonna move out one case. That is case number 29. That's 2024 R-019. Mr. Richter.
Yeah, I'll go ahead and put together it with the other one, just it doesn't screw everybody up too much. We received a call this morning from the treasurer for the Parma Democratic Party, asking that the matter be continued to a later date. They were working to file their reports. And so there's one other case down toward the bottom, item number 37, Eva Karas, 2024 R-035. Those two matters, I'm asking that the commission continue upon the request of the respondent. In this particular case, they've reached out and said, could those matters be continued so that I can take care of their filing? So I believe it's appropriate for us to give them more time to file their reports. So I would recommend both those cases.
What is the other case, Mr. Richter?
Item number
This one?
2024 R-035, item number 37.
Okay, so I just want to make sure everyone is clear on which two.
Understood.
Yeah,
That's what I was trying to do as well.
one
Appreciate
is case number 29. That's the Parma Democratic Club. That's case number 2024 R-019. The second one, you're recommending that we vote on these together?
Yes.
Continue both of them together?
it. Since it's for the same reason,
Okay.
yes.
The second is case number 2024 R-035. That's, the recommendation is to continue.
Correct.
So moved.
Second.
It's been moved and properly second. All in favor, say aye.
Aye.
All opposed? That has been approved by a vote of 6-0.
Thank you all.
Thank you. And next, we're going to go back to the $25 a day with reconsideration option. The cases are 2023 R-533, 2024, and all of these, the remaining are 2024 R-016, -018, -029, -040, -041, -046, -047, and -052. Mr. Richter.
Madam Chair, members of the commission, these are all cases where either for the first time or maybe we've had a prior case, the reports though have not been filed. It's either first time or near first time before the commission. And so my recommendation at this point is to find a violation and impose a fine of $25 per day, but to give the respondents the opportunity to file the reports and request reconsideration, which presumably will be done. I'll kind of aside point out, there are a couple of cases on here from Summit County where the person I work with at Summit County has indicated, well, they're planning on coming in this week and file their reports. I'll keep you apprised. I said, keep me apprised. I never heard another word. So hopefully some of those groups will actually get their filings made and we can go ahead and reconsider their cases. But right now, the reports have not been filed.
Thank you, Mr. Richter. Is there a motion?
So moved.
It's been moved by Mr. Lyles. There's a second.
Second.
Been seconded by Mr. Polkey. All in favor, say aye.
Aye.
Any opposed? That's been approved by a vote of 6-0. The next two cases, the first one is 2023 S as in Sam -040. The second is 2024 R-028. This is $25 a day with reconsideration option with a payment of $250. Mr. Richter.
In each of these cases, there was prior matter that the commission imposed a per diem fine of $25 per day. They're now back again. The reports have still not yet to be filed. And so my recommendation is to find a violation. Impose a fine of $25 per day, give the respondents the opportunity to have the matter reconsidered if they make a payment of $250.
Thank you. Any questions of the executive director? If not, is there a motion?
So moved.
Been moved by Mr. Knight. Is there a second?
Second.
Been seconded by Mr. Polk. All in favor, say aye.
Aye.
All opposed? It has been approved by a vote of 6-0. The next case is 2023 R-532. This is consolidate with case number 2023 R-458. Find a violation and impose a fine of $25 a day with reconsideration option with the payment of $250. Mr. Richter.
The essential circumstances are the same as the prior two matters we just dealt with, except that there is also an outstanding matter that has not yet been addressed by the commission. So I'm recommending that we consolidate the two cases and make the same kind of finding as we did in the prior case. I'll be glad to answer any other questions the commission may have.
Any questions? If not, is there a motion?
So moved.
It's been moved by Mr.
Second.
Polk. It's been seconded by Mr. Lyle.
Lyle.
Okay, thank you. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. The next case is 2023 R-541. Consolidate with case number 2023 R-462. Find a violation and impose a fine of $25 a day with reconsideration option with a payment of $250. Mr. Richter.
This is just a different name, but essentially the same circumstances as the prior matter. That in this particular case, Tracy Ware has had a prior violation where we imposed a per diem fine. There's an outstanding matter, and so I'm recommending we consolidate those cases and then impose a fine of $25 per day, but give the person the opportunity to have the matter reconsidered if they make a payment of $250.
Thank you, Mr. Richter. Are there any questions of the executive director? If not, is there a motion?
So moved.
It's been moved by Mr. Lyle. Is there a second?
Second.
Thank you, Mr. Polk. It's been seconded by Mr. Polk. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. The next two cases, 2023 R-595 and 2024 R-050. This is to consolidate cases, find a violation, and impose a fine of $25 a day with the reconsideration option with a payment of $900. Mr. Executive Director.
This particular individual had a couple of matters in which the commission, to which reports were filed, the commission imposed fines. Those have not yet been paid. That's the reason why the amount is much higher in this particular case with the consolidation of matters. There's another case outstanding, 2023 R-595, along with 2024 R-050. So I'm recommending we consolidate those, find a violation, impose the per diem fine of $25 per day. Give the person the opportunity to have the matter reconsidered if they make a payment of $900. And that would cover any prior outstanding fines that are still pending.
Are there any questions of the executive director? If not, is there a motion?
So moved.
Been moved by Mr. Caraway. Is there a second?
Second.
Been seconded by Mr. Lyle. All in favor?
Aye.
All opposed? Been approved by a vote of 6-0. The next three cases, the first is 2023 S as in Sam -036. Second is 2024 R-038. And the third is 2024 R-113. This is $7,150 plus $25 a day with reconsideration option. Mr. Richter.
These matters generally there are two prior violations in which the commission imposed per diem fines. They are now back for the third time, and so the $7,150 reflects the amount outstanding from the date the reports were due. These are generally for post-general election reports to today's date, which were again is equal to $7,150 plus $25 a day on into the future. But give the respondents the opportunity to have the matter reconsidered if they file the reports. No reports have been filed.
Thank you, Mr. Richter. Are there any questions of the executive director? If not, is there a motion?
So moved.
Thank you, Mr. Wolke. Is there a second?
Second.
Mr. Lyle, thank you very much. All in favor, say aye.
Aye.
All opposed? That's been approved by a vote of 6-0. The next cases are all 2024 R. First is -053, -095, and -120.
These respondents have multiple matters, multiple matters in which the report has not yet been filed. They're still outstanding, or this particular filing is still outstanding. And so my recommendation is to find a violation and impose a maximum fine amount of $100 per day, which is what the $28,600 represents to today's meeting date, and forward $100 per day, but give them the opportunity to have the matters reconsidered. If they file the reports, excuse me, and request reconsideration of the commission.
Are there any questions of the executive director? If not, is there a motion? Gentlemen,
So moved.
it's been moved by Mr. Quilke. Is there a second?
Second.
It's been seconded by Mr. Caraway. All in favor, say aye.
Aye.
All opposed. Oh,
Just really
that's
have
been
to pull
approved.
them out,
I
right?
know. That's been approved by a vote of 6-0. You guys are getting tired.
I was waiting for Mr. Caraway to talk about the issue with the, how big it is. I wanted to give that opportunity. for that.
In fairness, Mr. Richter and I have been trying to get together for a couple of weeks. We hope to come up with a plan to present all of you. So I am, for the moment, done complaining about it until I'm ready to help offer a solution.
Key phrase is for the moment.
For the moment, yes.
Thank you all very much. Next, we have a couple continued for service.
Continue those.
Yes, I'm going to
We did that
continue
one.
for service, case number 2023 R-561 and case number 2024 R-090. And these are being continued for service. We have a couple on reconsideration, and the two cases are 2024 R-111 and 2022 R-574. And this is to reconsider cases 2020. Case 222, isn't this 2022 or
2020, oh,
2022? Yeah, 2022 R-574. Okay,
Yes.
not
And-
222, but 2022
Correct.
R-574.
And
And they-
2024 R-111, which is pending before the commission.
Okay. And that would be to vacate the previous imposition of the per diem fine, FINE, consolidate the cases, find a violation, and impose a fine of $400, Mr. Rick.
This organization has a bit of a history before the commission. They've had some fines and paid them, and others they haven't. And so my recommendation here is to actually, part of it comes, I talked to the new treasurer for the committee, who's asking us to be, I guess I'd say, be kind to him, because he just took over the committee in the last couple of months. Reports have now been filed. They're in compliance. The prior treasurer was, he had various arguments that he just didn't realize reports needed to be filed. I understand why. And so my recommendation is you can read it, reconsider the one prior case, then vacate the previous imposition of the fine. In that case, consolidate these cases, find a violation, and impose a fine of $400. I'll be glad to answer any questions the commission may have.
Are there any questions, Mr. Kirschner?
What was the initial fine for the 2022 case, and what would that amount to today?
Well, it was a per diem fine, $25 a day plus, from the date that was due.
A lot bigger than $400.
It would be a lot bigger than $400, correct. Much more substantial than that.
And so
Well into 5 figures.
I don't know that a new person taking a treasurer position absolves the entity of their obligations. What are the extenuating circumstances? Are we able to hear more about this, or are we just kind of?
Well, I mean, I think one statement I would make is where you say absolves it, then you would be looking at not imposing a fine at all.
Well, 400 is pretty close to.
Well, okay, and I don't necessarily disagree with that, but I guess, the other treasurer resigned the position, the new treasurer offers a policy, indicates that they will be more diligent He previously run for elected office, takes campaign finance seriously and indicates he will do so. Yeah, I mean, it's always a balancing act between, you know, what you try to do for a penalty and trying to take into consideration
Have you,
I can't-
what is the number,
what
the amount that would be due to that?
on these otherwise outstanding matters. Like I said, it'd be well into five figures. It'd be well into five figures. I understand that. You know, but we'll generally bring it back to, you know, depending on how many outstanding and all those kind of things. You know, if it's only one or two, it might be $100, $200. We have reconsidered matters and had obviously much more substantial, up to about 1,000. You know, I mean, at one level, I picked 400. You know, to be honest with you,
Just
I
to
felt that
clarify,
that was equitable, but I understand your concerns and your comments.
was the only clarification that one treasurer left, the new one comes in and takes it more seriously?
That's certainly a part of the equation, yes.
What else was there?
That's probably it more than anything else, to be honest with you. Yeah, I mean, the original treasurer is the one who requested reconsideration, and then the other gentleman followed up with me later on to say, you know, hey, kind of what's going on here. I think, you know, not that. And honestly, a part of it comes, okay, what amount is outstanding? I think he indicated to me they have about $1,300 outstanding. And so, you know, trying to take a reasonable amount out of what was there without taking it all, certainly that plays into my recommendations as well.
Thank you.
Madam Chair, if I
Yes,
may,
go
too,
right-
I
right
was
ahead.
looking at the ICW and it says, I'm assuming that this is accurate. It says the committee is currently in balance and all outstanding reports have been submitted. So, I mean, one thing that goes along with the fine is compliance that we always try to seek. So, I don't disagree with what you're asking here because the fine was, I mean, back in 2022, it was, you know, $34,900 back then. So again, this goes back to what Mr. Caraway had raised and what we're all talking about. So hopefully we'll have some line that we draw going forward. But I just wanted to throw out that compliance is a big piece, part of all this, at least my experience on being on board.
Agree. I guess my challenge is less with this, and it's more when we, you know, are given $100, $200 fines to repeat offenders who also pay all their fines.
Yeah.
My bigger challenge is with, if we're gonna be lenient on this end, you know, we should start being more lenient on that end, is my opinion.
I agree. People that pay, yeah, I don't disagree.
Any other questions or comments? If not, is there a motion?
So moved.
It's been moved by Mr. Lyle. Is there a second?
Second.
It's been seconded by Mr. Colby. All in favor, say aye.
Aye.
All opposed?
Okay.
Okay, it's been approved by a vote of 5-1. That is the last case. And then with respect to other business, our next meeting date has been moved to October the 17th, 2024.
Yes, so that's always been on the commission schedule. It is there. That's the next date. We have numerous back and forth conversations about setting next Thursday for the continuation of
We're not meeting.
the Stewart versus Hicks matter. One of the persons that Mr. Hicks has subpoenaed cannot attend for personal religious reasons. One of his witnesses. To this point, I have not been able to get service on another of the witnesses. And so I will be continuing the matter. I've informed the parties, Mr. Stewart, Mr. Garvin, the other attorney for the respondent, and Mr. Hicks of my intent to do so. And so now I was waiting to officially do it until we're all here. Now that we're here, know that I am continuing next Thursday's meeting, so that there will be no meeting essentially. Since that's the only thing we had on the agenda. I am anticipating setting the matter, right now I'm anticipating setting the matter for November 7, which occurs after the election, because Mr. Stewart had, I think, somewhat appropriately expressed concerns relating to his participation in the upcoming general election, conflicts related to that. And so out of respect for that, I'm anticipating setting the matter for November 7th. That's still unofficial, because I'd hate to go ahead and set that again and then have somebody come back and say, oh, gee, I've got some other reason for not appearing. But that's my intent at this point.
Are there any other questions of the
Madam
executive
Chair,
director, Mr. Polkey?
Just a clarification, and the Hartman case will be held on the 17th,
On the
correct?
17th, that is
So I can
correct.
be-
Your presence is requested.
Thank you.
Thank you for sharing that, Mr. Polkey. Any other questions?
Madam Chair, yeah, I just have a friendly reminder to Mr. Richter. On our group recommendations, the board had requested before that you give us a summary rationale as to your recommendations. I've done that a few times.
I didn't remember to do that this time. I apologize.
That's okay.
I was noticing that too as we're going through here, because all of a sudden I'm just kind of.
Well, it saves you time. It's helpful for us
I know.
to see it. So if you could do that, we'd all appreciate it, I'm sure.
Thank you very much, Mr. Lyle. Any other questions or comments, Mr. Caraway?
One comment, and I'll be very brief, Madam Chair. Mr. Richter, it seems like in the last year, there was some language inserted, it may have been budget language, that talked about fictitious, political parties, either Democratic or Republican. I have tried to find that. Some of it came across in some filings with us in out of Summit County. The chairman up there, Brian Williams, I remember reading it, from him. Are you aware, even what I'm talking about?
The only thing that I can think of is I can't remember exactly when it was done, but the change to the disclaimer statute that, it's part of what was in the Campbell and McManus case, 35-17-20H. No political action committee shall use or cause to be used in the making or issue of a publication, included with the provisions of such a name or address that would lead a reasonable person to believe that the publication or communication is made by or on behalf of the county political party.
Okay, that may
I think
be,
that's what you're talking about, because I'm not aware of anything else
okay.
similar to that aside from this.
I'll go and look at that and on the website, you can tell when the last time it was updated, that section of the code.
Right.
But I am starting to see what I believe could be a disturbing trend, in both parties of, it seems like someone doesn't like the result of their local political party, so they just, I'm gonna do it this way. And it does confuse voters. I've seen it firsthand where you actually have a reasonable, a fairly well-informed voter that is confused. But I know that's not our place to set policy, but I wanted to better understand the law a little bit, so I'll take a look at that. Thank you, Madam Chair.
I think that I'm pretty sure that's
Okay.
the provision we're talking about. I don't recall exactly when when it was enacted or put into place, because I haven't looked at that aspect of the statute for when. Excuse me, but it's been within just the last couple of years.
Yeah,
It has to be, because when I was running for office, we had entities developing sample ballots
Right.
with some endorsed candidates by the local party
Right.
and others not, to
Yep.
confuse the voters.
Yep.
And, we would have to get a judge to hold seats,
Well, and I
those
think that
activities.
Mr. Lyle and Mr. Knight were talking about that case out of Hamilton County earlier, and I think that was the first time we'd seen that particular provision presented to us, as I recall. And so I'm pretty sure that's what it is.
Thank you. Any other questions or comments? If not, is there a motion to adjourn?
so,
Been moved by Mr.
One, I
Caraway.
told you.
okay, go ahead.
Is there a second? You're gonna second?
Second.
Okay, it's been moved and seconded. All in favor?
Aye.
Opposed? Okay, that's a unanimous, 6-0.
Fairway, so
Thank you.
Thank you.
promised,